All we need, Miss Lindsay, is a copy of the first page, so she's got the site and the spelling of the name. All we need, Miss Lindsay, is a copy of the first page, so she's got the site and the spelling of the name.
Thank you very much.
Okay, we're back on the record in the matter of the people of the state of Michigan versus Mateen Cleaves. Oh, my computer's not going. Okay, we're back on the record in the matter of the people versus Mateen Cleaves. 16T 538FY. Now, let me tell everybody how this is going to go, and there's to be, I will brook no misbehavior. Let's characterize it that way. I am going to rule, and I will not be interrupted. I won't tolerate any of that. When I'm done ruling, you may put your objections on the record. I will not answer them. I'm going to get up and adjourn and leave after you put your objections on the record. But I will give you time to put your objections on the record. So, I'm deviating a little bit from what I normally do. Miss Lindsay, you wouldn't know what I normally do, but I normally go clause by clause in the statute, and I'm going to deviate a little bit from that and start with some other things first. First of all, according to Black's Law Dictionary, a preliminary examination is a hearing by a judge to determine whether a person charged with a crime should be held for trial. A hearing held in felony cases prior to indictment, which the state is required to produce sufficient evidence to establish that there's probable cause to believe A, that a crime has been committed, and B, that the defendant committed it. Probable cause is defined as reasonable cause, having more evidence for than against. A reasonable ground for belief in the existence of facts warning the proceedings complained of. An apparent state of facts found to exist upon reasonable inquiry. Parenthetically, that is, such inquiry as the given case renders convenient and proper, close the parentheses, which would induce a reasonably intelligent and prudent man, I will add there woman in this case, to believe in a criminal case that the accused person had committed the crime charged, or that in a civil case that a cause of action existed. So here I sit as the judge in a preliminary examination wherein I must find whether or not there is probable cause to believe that the crimes charged were committed by this defendant. Under count 1, did knowingly restrain the complainant to facilitate the commission of assault with intent to commit sexual penetration and or criminal sexual conduct in the 3rd degree and or criminal sexual conduct in the 2nd degree. I do not find that. I looked at the video again today, and there is no doubt in my mind after viewing it what is going on. But Miss Lindsay says I'm supposed to believe that he's pulling her back in the room to commit CSC. There are a number of factors that lead me to believe something else could be going on, and I'll tell you those factors. First of all, she is the one that invited Mr. Cleaves to come to the bar. She is the one that voluntarily left with Mr. Cleaves to go to, left the bar, to go someplace else. Warwick, I think I can take judicial notice, would have been closed by then because it was close to 2 a.m. She is the one that goes into the lit gas station, says she's concerned, but she's not concerned enough to let her boyfriend answer the phone when it's ringing. She's not concerned enough to warrant, asking the attendant, I don't want to go with this man. Please call my boyfriend. Here's his number. I just don't believe there is enough probable cause for it to go over on false imprisonment. 2, criminal sexual conduct, assault with the intent to commit sexual penetration. I went through all the factors of why I believe she voluntarily went with Mr. Cleaves. Does that mean that CSC could not have been committed? No, it doesn't. So I have to look to her testimony. And regardless of what Miss Lindsay says, it is my job to judge credibility when a hearing is being held in me for probable cause. The complainant says to the forensic nurse, who has no dog in this fight whatsoever, I have not had consensual sex within the last 96 hours. She says that. But yet there were 2 male sperm donors found. Where did the other one come from? She also tells the nurse, I'm on hydrocodone and Motrin, and she danced all around that. And she danced all around whether that was her in the car at the front of the hotel. Well, you can assume it's me. No, I don't recognize the purse. No, I don't remember. As to counts 2, 3, 4, and 5, this court has not heard enough to bind them over. This case is dismissed. Now I will listen to your objections.
Your Honor, I just want my order today, please. If I can
Pardon
have it.
me?
Can I have my order today?
What order do you want, ma'am? The only thing I
The
have...
dismissal order.
Can I finish? The only thing I have that I can give you is an SCAO form called a miscellaneous order that I can give you that says I find no probable cause to bind counts 1 through whatever it is, 5, over to circuit court. That's all I can give you.
That's what I'd like today, thank you.
You may have that today. Do you have any objections you want placed on the record, Mr. Manley?
No, Your Honor, thank you.
Court's adjourned.